Good morning and welcome to today's Weltman webinar. Today's topic is Real Estate in Chapter 13 Bankruptcy Cases, Life After Confirmation. My name is Milos Gvozdenovic and I will be the moderator for today's session. I'm a shareholder for Weltman's Bankruptcy Group and I practice out of the firm's Cleveland office. I've been practicing bankruptcy law for over a decade and I'm a member of the Cleveland Metropolitan Bar Association. Let's learn a little bit more about our other presenters, and we're going to start with Garry first. Garry, if you could introduce yourself.
Good morning, everybody. My name is Garry Masterson. I've been with Weltman for approximately 5.5 years. I'm admitted in the state of California, and I practice bankruptcy for Weltman in New York, Pennsylvania, Ohio, and California.
Thanks, Garry. Erin, if you could introduce yourself as well.
Sure. Good morning, everyone. My name is Erin McCabe, and I am been with Weltman for about 11 years, and I typically handle Kentucky and Indiana for the firm in the bankruptcy department.
All right, before we get started, I just want to go over a couple housekeeping items. Just a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording will be sent to all attendees. And lastly, there will be a short survey on your screen at the conclusion of the event, so please take the time to take the survey and share your feedback. We really appreciate getting your opinions on these matters, and they kind of help shape events in the future. Finally, we have to read our firm's webinar legal notice. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. The seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. I advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman, Weinberg & Reese. All right, now that we have that out of the way, let's get into the presentation, and Garry, you're up first.
Good morning again, everybody. So what I'm going to cover is treatment of mortgages within a Chapter 13. And at the outset, I'll mention that I know for many of you, this is something that may have fallen off your radar just due to lack of being an issue since COVID started in early 2020. What we're starting to see more now, and you may be seeing as well, is real estate is coming back to the forefront, both in foreclosures and also then within bankruptcies. So it's an important topic to cover to make sure that you know what you need to look for, what the effects of bankruptcy are on your property, and what time factors there are that come into play as well. So I have a handful of categories that we're going to go through. If you have questions, as Milos mentioned, that come up during the presentation, please feel free to submit those, and we will get to those either during my part of the presentation or closer to the end as well. So when a debtor or member of yours files bankruptcy, many times the first question is, what effect does this Chapter 13 filing have on my account, and specifically on a pending foreclosure that I may have out there? So at the outset, the bankruptcy filing itself operates as a stay on any foreclosure case or action or sheriff's sale, and that is immediate. As soon as that case is filed, you need to stop any of those actions. The foreclosure case, if it's pending, cannot be further prosecuted or proceed once that bankruptcy case is filed without you affirmatively filing a motion with the court and then obtaining relief from stay in the bankruptcy case first. If you've already proceeded to judgment in the foreclosure case and judgment's been entered, if there's a sheriff's sale that is scheduled in the future, this will need to be either canceled, postponed, vacated, if relief from stay is not obtained before that sale proceeds. There sometimes have been instances I've seen where you will have a foreclosure judgment, you'll have a sheriff's sale scheduled, there's no bankruptcy, And either the eve before the share of sale, or sometimes the same day of the share of sale, the debtor will file for bankruptcy. And depending on that timing will affect if you need to quickly stop the sale or if you need to go back and potentially vacate too, depending on, you may have received notice, say tomorrow morning, but the sale already happened before you were aware bankruptcy was filed the prior day. When you filed for relief from stay in the bankruptcy, once that is granted, along with if the 14-day stay is waived or is not waived, once those appropriate periods have run, then foreclosure and or sale can proceed as normal under the state law you're operating under. Another important factor to keep in mind is if a debtor has filed bankruptcy multiple times in order to keep blocking your share of sale, or it operates to have that effect, you should consider filing for what is called in rem relief from stay, if appropriate. And if this were granted by the court, what this would do is you can record that order and it would allow the relief to attach to the property for a set time period, sometimes 2 years, and allow you to proceed to sale and finally sell the property without the debtor being able to continuously proceed in filing bankruptcies to just stop you from selling your property. And the final important item in this category is, while you're pursuing a relief from stay, you should also be sure to not just assume that's going to be granted and you're going to proceed against the property. You need to make sure to also affirmatively participate in the bankruptcy case in all aspects. So this means filing a proof of claim, reviewing a plan if and when it's filed, objecting to the plan if necessary, monitoring case events, and everything else that you would normally do within the bankruptcy process. So make sure you do that even while your motion for relief is pending. The second category I'd like to cover is the effect of a Chapter 13 on pre-petition, so before the bankruptcy was filed, mortgage arrears and the cure of those. So most times when your account is behind and the debtor files bankruptcy, they will put those pre-petition arrears on your account in the plan. When that happens, those arrears are going to be paid over the life of the plan, which is normally 3 to 5 years, by the trustee. So you'll receive payments on those pre-petition arrears. In many instances, you're going to receive more than one type of payment per month. You might receive payments from multiple different sources. You may receive payments from a trustee for the pre-petition arrears that we mentioned. You may receive a separate payment for the post-petition payments that come due according to your mortgage from the trustee, or you may also receive those post-petition payments directly from the debtor. So it's very important that you make sure you apply the payments appropriately. If the trustee is paying on pre-petition arrears, make sure when those payments come in that you apply those to the oldest pre-petition arrears that are due. If a payment comes in from a debtor for a post-petition payment, so after the bankruptcy is filed, make sure you apply that payment to the oldest post-petition payment due. Meaning, if the debtor filed today, December 8th, and they're next due on their mortgage for after that date for December 15th, if you receive a payment from the debtor in that instance, you want to make sure to apply that payment to that December 15th date and not your very oldest due before the bankruptcy was filed. The reason for this is failure to account for those differing payments correctly can lead to not only confusion, but also things you want to avoid. Problems with the court, problems with the debtor and the trustee. If, for example, you need to file relief from stay. What you don't want to do is, beyond the confusion, you don't want the court, or trustee, or debtor's counsel to question if you know what you're doing, why you can't account for funds correctly, and things like that. It just makes you look bad, and when you're trying to get relief, it just brings doubt to the whole situation. The third situation I want to cover is sale of the property. So quickly in this category, you want to make sure you monitor the case for if the debtor decides to propose selling your property within the bankruptcy. They may do so. Court approval is required for any sale while the bankruptcy is pending. It is very important that if you receive a sale motion, that you very quickly consult with your bankruptcy attorney, because there's normally a very short time period to file a response or an objection if that's needed. 14 days, 17 days, somewhere in that range. So you need to make sure the terms of the proposed sale meet with your approval and cover all aspects of your account and the property in general. One of the most important parts in Chapter 13 is what we call the anti-modification rule, and this is in regards to a primary residence. By primary residence, we mean the debtor has a mortgage, and the property that secures the mortgage is the property where the debtor resides and lives. Generally, a court cannot approve a Chapter 13 plan that modifies the terms of your mortgage if the principal residence of the debtor secures your loan. They cannot cram down the principal balance due on your loan. They cannot lower the interest rate. They cannot lower the monthly mortgage payment amount. And in this situation, they cannot extend the term on your loan or increase the number of loan payments. Of course, as always, there's exceptions to the anti-modification rule. One major exception is what I mentioned previously, that the debtors have the ability to cure the pre-petition arrears while maintaining the post-petition payments to you. The only requirement for what we'll call cure and maintain to be allowed is that the plan is feasible. What this means is that the debtors have to be able to fund the plan that they actually propose. They need to show they can make those plan payments plus maintain their other ongoing expenses. Your post-petition payments, maybe their car, food, electricity, all those expenses. They need to show that they can actually fund the plan and pay everything else. Another exception is early maturing mortgage loans. So an early maturing loan is any loan that matures before the final plan payment comes due under the Chapter 13 plan. In this situation, the normal restrictions regarding anti-modification are removed. A plan could be approved that lowers the interest rate paid while the bankruptcy case is pending, could lower the monthly payments, or could lengthen the loan payments for up to 60 months, i.e. the life of the bankruptcy plan. They could also cram down the principal balance on the loan to the value of your property. In this situation, the dollar amount of the valuation of the property could become into dispute and could be a basis for you to object to the plan. And then in that situation, many times it'll be a so-called battle of appraisals and where's the value of the property fall, and does that allow them to cram down in that situation. Another thing to keep an eye for is the possibility they could strip liens regarding junior mortgages and home equity lines of credit. The debtor can seek to avoid junior liens, such as a second mortgage, as well as other judicial liens on the property. In order for them to strip your lien in those situations, it must be found that you are completely unsecured. This results in a math equation looking at the property value and any liens that are senior to yours. If those senior liens total and exceed the value of the property, also accounting for any validly claimed exemptions by the debtor, you can be treated as unsecured. In those situations, if your lien is stripped, you will be paid as an unsecured creditor. However, it's important to remember, if the case is dismissed, your account does revert as if the bankruptcy didn't happen, and you retain your lien rights and your security interest. Just as with the prior section, the contested value of the property can be a major part of an equation in these situations. It's very important, as I mentioned before, when I was talking about possible relief from stay and making sure you monitor the bankruptcy case, to timely and adequately review any proposed Chapter 13 plan. Just as you experience in non-real estate situations, so vehicle or anything else, failure to timely review a plan and timely object can have a detrimental monetary effect for you and your organization. You will be bound by the terms of the confirmed plan, so you need to be sure to review the plan as soon as it is filed, or have your bankruptcy attorney review so you can file a plan objection if needed, and also so you're aware of your treatment, because as I mentioned before, with the multiple potential payments from different sources, you need to be sure where the funds are coming, that it's notated on your side. So whether it's you or it's another department in your organization that processes payments, they're aware of how payments need to be applied. Also, a major timeliness issue is filing a proof of claim. Make sure you file a proof of claim. If you have a balance and you have a valid claim, before the proof of claim deadline or bar date that is listed on the notice of bankruptcy you receive. If your account is still secured and it's not a deficiency balance, make sure you file it as a secured claim. If you've proceeded to foreclosure, you've scheduled a sheriff's sale, the property has actually been sold, and your account is now just a foreclosure deficiency, file that as unsecured. And then the final item I want to cover is, along with proofs of claim, the 410A form, which is an attachment to the proof of claim for primary residences. It can be a point of confusion as they can be extremely complex at times, especially if an account is significantly behind. So when you're filing a proof of claim for an account secured by the property that is the primary residence of the debtor, reminder again that that's where they live, you will need to make sure this 410A form is completed and included with that proof of claim. If the account is current, it can be fairly straightforward based on the items you need to track and itemize on 410A. However, if the account has arrears, it can be quite complicated and can span multiple 410A form pages. If there's significant arrears, I strongly recommend having a bankruptcy attorney handle this 410A form for you, as not only can it be time consuming, confusing, and extremely detailed, you don't want to put yourself in a situation where you're drawing a claim objection, having to expend additional litigation fees to your bankruptcy attorney to resolve something that perhaps with a little more detail on the front end could have been avoided to begin with. So in a nutshell, those are the areas to keep an eye on and look for in a Chapter 13 when a mortgage is concerned. And I will now turn it over to Milos.
Thank you, Gary. I appreciate the presentation. Very good stuff. We have our first question through the chat, and one thing I forgot to mention earlier is we did get questions ahead of time. A lot of good questions, and we should have plenty of time to address those questions at the end of the presentation. I'll let people know that we are going to prioritize them by things that are closer to the subject matter that we're discussing, and then obviously the ones that may be a little off topic, we're going to save those for last. But one of the questions that we got ahead of time and that was just sent to us on the chat is individual or the lender obtains a judgment in foreclosure where they get the foreclosure judgment and the debtor files for bankruptcy the day before a sheriff's sale. Very common thing. A lot of times people try to save their houses, they wait till absolute last minute, and they file their bankruptcy before sheriff's sales goes forward. The question is ultimately, is the foreclosure judgment still enforceable if the debtor defaults on the plan? So the way I'm understanding that is if the plan fails and the foreclosure resumes, do you have to start from scratch or do you pick up where you left off? Normally you pick up where you left off. Now obviously, excuse me, you want to consult with your attorney who's handling the foreclosure because it depends on the district and what rules they have. But typically, from my experience, if the Chapter 13 is filed and it stops the foreclosure and then 13 ends up getting dismissed, you can resume the foreclosure where it left off and proceed moving forward with the sale. One other thing to add is if the sale actually goes forward before the bankruptcy is filed, but the sheriff never confirmed the sale, or the deed was never transferred to the purchaser, at least in the districts that I practice in, it's too late. You would normally file a motion for relief from stay and object to the plan and attach that sale order as an exhibit, because a lot of the case law, that at least that I've encountered, has indicated once the property is sold, the bankruptcy can't undo it. It can only stop the foreclosure where it's at, but not go back and unwind what's already been done. So, and like I said, that may be different in other districts depending on the case law, but it's worth looking into if you get to the situation where the property is actually already sold, and then the member tries to file bankruptcy and save the property. So, I don't know if you guys had anything to add to that. If not, I was going to move forward to my topic. All right. So the topic that I'm covering today is notice of payment changes. So if you can move the slide one. There we go. Okay. So what is a notice of payment change? Before I get into the specifics of it, ultimately, when somebody files a Chapter 13 bankruptcy, as Gary indicated, you file your proof of claim, you file your 410A form, and then depending on how the plan is set up, 99% of the time, the plan is either going to have the trustee make the payments for the pre-petition arrearage and the ongoing mortgage payments, or the debtor. So the notice of payment changes is basically a notice that has to be filed with the court to put everybody on notice if there's any change in the mortgage payments. Because the trustee and the debtor and the debtor's attorney are not going to know what they have to pay unless you put the court on notice in terms of what the payment is. And some of the common things that would spark a payment change is obviously change in interest rate, escrow adjustments. Sometimes you have a line of credit that goes from a draw period to repayment period. Those are probably your three most common things. I don't know what other scenarios you would see a payment change, but those are the ones that I would probably say encompass all the payment changes that we see. So notice of payment changes are governed by Rule 3002-1 of the Federal Rules of Bankruptcy Procedure. The rule specifically says that it only applies to claims that one, are secured by a security interest in the debtor's primary residence. So what that means is you're only required to file notice of payment changes in properties that the debtor is actually using as their residence, that they're living in. Two, it has to be in situations where the plan provides that either the trustee or the debtor will make the contractual payments. I don't know what situation would arise where the debtor or the trustee aren't paying. The only thing I could possibly think of, and obviously the rest of the panelists can give their input, is where there may be a co-debtor or a co-signer on a loan, and the plan provides for that co-signer to make the payments directly, and not for the trustee or the debtor. So that's the only scenario I see where that doesn't apply. And the other thing is the rule says that the notice of payment changes are required for a security interest in a debtor's primary residence. We don't see a lot of files where a debtor files and they have multiple properties. It does happen, and I guess if you read the rule as it's written, you're not required to file notice of payment changes for any non-residential properties. But my thought has always been, depending on how the plan provides for treatment of those other properties, how is the debtor or the trustee going to know what they're supposed to pay if you don't file a notice of payment change? So even though the rule says it's only required for primary residences, I think if there is additional property where a family member is living, or they're using it as a rental property, I really think that it would be good practice as a matter of precaution to file a notice of payment change, even in those situations as well. So, one of the questions that we received prior to this is, when do you have to file a notice of payment change? The notice of payment change has to be filed at least 21 days prior to the new payment being due. So if we're currently in December, and if you had a payment change that's going to take effect January 1st, you got to count 3 weeks back from that date, and that notice of payment change has to be filed with the court at least 21 days prior. And this is for any type of a payment change, whether it's interest changes, escrow changes, anything along those lines. So what are the repercussions if you don't file? The worst thing that could potentially happen, which depending on how drastic the payment change is that the trustee won't honor the new payment. So if you have a payment that changes January 1st and you file your payment change on, December 30th, the trustee may say, too late for January, you're going to get your old payment. And then we'll, if that new payment change is we're going to pay it on the next month. So it's very important to get those in timely. I don't want to say that a trustee will honor it if it's late, but sometimes if they haven't made the distribution and you get it on time, they may honor that payment change, even if it is late, but I wouldn't count on it. And especially if you file it past the due date. We've had situations in the past where that's happened. Someone forgot to file a notice of payment change, 12 months go by, and then they file it. Before this rule was changed, the trustees would go back and retroactively adjust it, but this change in the rule was made, I think, in 2020, if I remember correctly, where they put in the 21-day requirement, and I think it's not to burden the debtor and trustee, which makes sense. If somebody makes a payment on their mortgage and then you come a month later and file a notice of payment change, like, oh, it was wrong, now you have to do all that stuff. The responsibility is on you to make sure to file it timely. And if you don't, you're stuck by the payment that you receive from the trustee. So what that means is you can't, if you don't file a notice of payment change and you pay it late and the trustee does not pay enough to cover that payment, then you're going to have to just write it off. You're not going to be able to just slap it at the end of the loan or, make an adjustment for the next month or anything like that. You missed your opportunity, and the penalty is you're not going to get that money, and you can't pursue that money. When you file a notice of payment change, the payment change is presumed to be correct unless somebody objects. So if you could flip one more slide. The presumption is in your favor. So if you file a notice of payment change for an adjustment in escrow or a change in interest rate, the trustee is just going to honor it. So unless the debtor or debtor's attorney says, wait a minute, something's wrong with the taxes, like the escrow's off, they may file an objection, or they may say, that's not the correct interest rate. They have to proactively file an objection to challenge that. So once you file the notice of payment change, it's presumed to be correct. So we'll go one more slide over. So one of the common things that's come up recently, there's some issues that you may encounter, is, what do you do in a situation where you have a variable rate mortgage where the payment changes every single month? Well, the reality of the situation is you are required to file a notice of payment change every single month, 21 days payment being due. Now, where it gets kind of tricky there is a lot of times that's a lot of work or potentially a lot of money. And a lot of times if it's an interest-only loan or if it's a really small balance home equity line, the monthly payment changes, but it's nominal. There's a couple ways to kind of get around that. I think the most common way and the right way to do it is the code section, or the rule section 3002.1B1 provides that a creditor can actually request a waiver of the requirement to file a notice of payment change if the claim arises from a home equity line of credit. So what commonly happens is, let's say the plan is confirmed and it says the debtor is supposed to make the contractual monthly payments or the trustee is supposed to make the payments. As a creditor, you can file a motion and say, listen, we have to do a notice of payment change every month. They're paying us directly already. We feel it's kind of pointless to do it. It would be just more efficient and cleaner and easier for everybody involved if we just eliminate the requirement and we can send the statements to the debtor directly. We've been doing that a lot frequently, particularly for a specific client, and we've had pretty good success because, our thought collectively is if the plan already provides for direct payment, instead of, filing a notice of payment change and then the court gets it and then the debtor's attorney has to send it to their client, I think it's much easier if we just eliminate that step and then have you send statements directly to the member. Most of the time, we don't have any objections. We did have one recently. One of the debtor's attorneys objected because he wanted to be a little more involved in his client's case, and he was afraid if he doesn't get the notice of payment changes, he's not going to know if there's any major adjustments, which is a fair concern. And I think a lot of times if we were to get pushback on this, my thought is always, you know, the reason we file it is to benefit all parties. If one party comes up and says this isn't beneficial to us, I don't know if the court would grant the motion, particularly if the debtor or debtor's attorney raises an issue with that. I don't know if either of the other panelists have any other thoughts, but
I mean, I think quickly on that, possible resolution if that happened would be perhaps we can arrange where either both the debtor's attorney and the debtor gets statements turned on to them, or while the case is pending, the creditor sends statements to debtor's attorney directly, and then that way it would serve the same purpose. So that's a possible solution on those.
Yeah, the other things that we've kind of explored for other clients is, we kind of, when you file your bankruptcy and you file the 410A form, the 410A form has a section in there specifically says your monthly mortgage is going to be X. That figure that you put in that 410A form is what's going to control what the payment's going to be from the time the case is filed until the case ends or until you file a notice of payment change. So sometimes we've had clients in the past where if they don't want to file a notice of payment change, they're willing to set a fixed amount. Let's say the payment when the case is filed is $300, then interest adjusted goes to $25. Sometimes it goes to $275. The client just says, we'll set it at $3, and if we get less, we'll just credit the member. If we get more, we'll apply it to the next month's payment. We just won't file a notice of payment change, and we're fine with a fixed payment of $300, and we'll adjust internally. The other thing that you could potentially do is you can reach out to debtor's counsel and say, all right, we're on an adjustable rate. Your client, we're changing the payment every month. Why don't we work out an agreement? Let's do a fixed rate and use the plan to modify the loan permanently, and then your client will just pay $300 a month at 3% interest through the bankruptcy, and then when the bankruptcy is done, they'll just resume those payments and we'll be done with it. So, we can get creative beyond the notice of payment changes or the waiver of notice of payment changes if you're willing to do it. So just something to keep in mind if things kind of get a little time consuming or financially consuming monitoring these payments every month. There are ways around that. And the one last thing that I wanted to kind of talk about is the 410A form itself. One thing to remember, as I mentioned earlier, is when you prepare a real estate proof of claim, there's a 410A form which is attached, which shows the payment history and some additional information. One of the things in the 410A form is the monthly payment. As I mentioned previously, the monthly payment that's put in that 410A form is going to control what the payment's going to be for the duration of the plan. The only way that that's ever going to change is if you file a notice of payment change. What I see a lot of times is clients that do their own claims or they send us the referral is they want to put the term variable in that section. The problem with that is we understand that it's a variable rate mortgage, but the trustee is going off that section of the form to determine what your payment is. So if you're just putting variable without a numeric amount, the trustee is not going to know what to distribute. So either they're not going to make a distribution, or other things I've experienced, the trustee will find something within the proof of claim, maybe the last payment, and they'll use that as the determining factor where the payment is, and then that's what it is, and then it's your responsibility to make those changes. I think the proper way to do it would, my thought is one of two ways. One is when you file the case, you determine what the actual payment is for that month after the case is due. That's what you put in for the variable amount, and the trustee will pay that. And then when the payment changes, you file a notice of payment change. Alternatively, you can put in variable as a placeholder, but as soon as you find out what the payment is or if the payment changes, you file a notice of payment changes as soon as you possibly can, and then the trustee will go after that subsequent notice of payment change. And like I said, failing to fill in that 410A form section or failing to a timely notice of payment change, the consequences are you stuck And if, you know, this plan goes 5 years and you never file the notice of payment change, and you say, you know, we got shorted $100 a month every month on this because the payment wasn't correct, tough luck. Well, I think at the end of the day, you're just going to have to absorb that loss if you didn't comply with the notice of payment change rule. That's all I have to go through specifically. I don't know if Garry or Erin had something they wanted to add to what I said. If not, we could move on to Erin's section of the presentation.
Yeah, nothing. Okay, great. Thanks, Milos. I appreciate it. Okay, under Rule 3002.1, there is a second section under the same rule Milos was talking about. It relates to a notice of final cure. So the purpose of a notice of final cure basically is telling interested parties that the debtor has paid in full the amounts required to cure the default on a mortgage claim. So how this works is basically at the end of the plan or the final payment under the plan, the trustee has 30 days to send out a notice to creditors, or the actual rule refers to holders of claim. Now remember, a holder of a claim is not necessarily the original creditor. In other words, you could, by transfer, receive the claim and you're not the original creditor. So the code actually refers to holders of claim. And so the debtor has 30 days to serve the holder of a claim to debtor and debtor's counsel. At that point, there's a trigger where the creditor then has 21 days to respond, 21 days from the service of the notice to respond. So the question is this required? And if you look at the wording in the rule 3002, it uses the word shall, and generally shall means yes, it's required. There's no may or permitted or something like that. So it is a requirement. So there are basically two official forms that the bankruptcy courts produce. One is form 4100N, and that's the notice. And then there's a form 4100R, and that's R for response. So these are, again, official forms. You may have a local form that your trustee uses, or it's not, you know, mandatory. I don't think that you actually use the forms, but they're laid out very nicely and they're easy to fill out. So on the 4100N, one thing to point out too, this applies to both mortgage payments that are gone through the plan or they're direct from the debtor. So it applies to both situations. So as far as the response, the 4100R, there's 5 sections to it, and the main second section basically has you either agree that the pre-petition arrears have been cured, or if they're not, then you need to fill in the amount that's still due. And then the section 3 has to do with the post-petition arrearages. So if you agree, again, that they're post-petition current, you would check that box. And if they're not, then of course, you've got to fill in the amount, which would include, you know, escrow or any kind of payment, you know, other fees, as well as the amount that is past due. And all these are, again, filed as a supplement to the proof of claim, by the way. So the question is, what happens if you do not file a response? So I did a little research, and it is sanctionable. And I believe Rule 3002 was amended. If you look on Section I, it talks about the failure to notify. So it's a sanctionable event. I found a case also in the Western District of Tennessee in 2015 where, you know, the creditor failed to file the notice of final cure, and you know, some time went by, and then the creditor said, hey, there was all these arrears due, and the debtor moved to reopen the case. And you know, and when you do that, you know, it's called a determination of final cure payment under the rules. So, you know, the court basically then would not allow any proof that they were behind. And secondly, they required the creditor pay for attorney's fees and costs. And it turned out to be an amount that was larger than the arrearage amount to begin with. So it's definitely sanctionable. In my opinion, I find out sometimes if, a creditor is current, that they sort of, on a few occasions don't really think that they need to respond because, in fact, they're post-petition and pre-petition current. So that's not the case. I would take it seriously because there isn't a chance that, you could get dinged for that. So another question kind of comes up: can you extend that 21 deadline if you find out, on the 20th day? And it's kind of unclear. I would say not, no, but as a general rule, I would say 21 day is a hard deadline, just like a proof of claim deadline that you have to, pay attention to. Another issue that kind of comes up sometimes is what happens if during the case that you have a motion for relief that was granted on the property. So and then later in the case, towards the end, the final payment's made under the plan, and the trustee then files this and sends out the notice of final cure. So some local rules basically give an exception to if relief is granted, but as a safety measure, again, I would still respond and put that in your response on your notice of final cure that perhaps relief was granted on this date, and just leave it at that. So I think that's about all I've got, Milos.
Yeah, we actually had a question come in, actually a very good one. Is the response to the notice of final cure, like a 4100R form, required only if the notice of final cure, the 4100N form, is filed by the trustee? I think, from my personal experience, I don't remember a situation where trustee has not filed it, because like Erin said, the rule says within 30 days after debtor completes all payments under the plan, the trustee shall file and serve on the holder of the claim, the debtor and debtor's counsel, a notice of stating the debtor is paid in full, et cetera, et cetera. So right. I think the requirement's on the trustee. If the trustee doesn't file that, I think they're subject to some issues or problems. But my initial thought, and if you guys have a different opinion, is if there's nothing to respond to, you don't respond. The rule only says you have 21 days to respond to the notice of final cure.
That's right, true. Go ahead, Gary.
No, I was going to agree that there's the two triggers. So the trustee has to do 30 days after plan payments, and as a creditor, your responsibility is not triggered until they actually do what they need to do, and then 21 days from service. So I would agree, if the trustee doesn't file anything, you don't have an affirmative duty to create a pleading.
And I believe the debtor actually can serve that notice of final cure as well. The counsel, perhaps if the trustee forgets or it's overlooked, the debtor can do it as well.
All right, so we have some time we had some questions that people sent in ahead of time, so we have plenty of time to kind of go over those. So I'm going to take these kind of in the order they came in, because I was sifting through them, and most of them fall, are pretty much on topic. Some of them we may have already answered. So the first question came up: how should creditor treat a foreclosure judgment in Chapter 13? I'm assuming it was similar to the question that was asked earlier. If you give the foreclosure and judgment in Chapter 13, unless it's a order for sale, I think you just you have to participate in the 13, and you pick up where you left off after the 13 gets dismissed. Here's a good question: how soon after non-payment to plan should a creditor file an MLS? I'm assuming that's a motion to lift stay, which is a commonly used term, or some districts say motion for relief from stay, or motion to terminate stay, all interchangeable. So once again, I'm going off of personal experience in the districts that I practice in. If the payments are direct to you, and the plan provides for direct payments on the mortgage, and the debtor is not paying, you file motion for relief whenever you want. Whatever your internal rules say, like, all right, they're behind one payment, we're going to be hyper aggressive, or say, you know what, let's give them 2-3 months, let's see what happens, we'll give them some opportunity to work. That's completely your discretion. Now, if the payments are coming from the trustees. The debtor's paying the trustee, and the trustee's paying your mortgage payment. Most trustees, but not all, that I deal with, I'd probably say if they fall behind on the trustee payments about 2 to 3 months, the trustee will move to dismiss. Now, you're not required to wait for the trustee to make the move. If you're not getting paid, same thing applies. It's your threshold of tolerance in terms of when you want to take steps to move for relief. But I would normally recommend let's not be hyper aggressive. I think most judges would kind of look at it and be like, all right, they're like 30 days late, and you're jumping on the motion for relief. We're not going to grant that. Let's give it some time to play out. But I think a good rule of thumb on both sides is I'd probably say no earlier than 60 days, and I probably wouldn't let it go more than 3 or 4 months delinquent.
I generally use two payments, Milos.
Yeah, I agree. Usually, same standard for whether you're talking a house or a car. 60 days, same thing for planned payments. Usually the trustees are pretty good when they fall behind, but I've noticed lately that, it could be due, from what I've heard, of short staff at the trustee's office as well. Some are slipping through the cracks. So I've had a good amount, I think about 5 recently, that I've had to file because they're thousands of dollars behind on their plan, have never made a full plan payment, and are going further in the hole. So, but generally 60 days.
Yeah, I would agree with Gary. I've noticed some of the trustees in the district I practice, and they've been letting it slide for like a long time. And I don't know if it's the current financial climate, they just want to give people as much opportunity as they can, or they're just short-staffed. But I've had some that have gone as long as 10 months and the trustee hasn't done anything. I mean, I think that's kind of ridiculous. So I wouldn't rely on the trustee to take the reins on this. I think you still have to be vigilant in those situations. Another question we got, these are actually really, really good questions for this webinar. So can you file for relief from stay if you are not receiving adequate protection payments, but you are oversecured? That's a really good question. I think generally speaking, for real estate, once again, I'm going off of my experience, the districts I'm in, you should be receiving your contractual post-petition payments pretty much right away. And I think a lot of times that's construed as an adequate protection payment because the trustees making the mortgage payments, you're getting payments. Payments on the arrearage, pre-petition arrearage may not start right away, but if you don't receive those right away, I don't know if that's necessarily grounds to file for relief for not getting adequate protection payments. Now, the second part of the question is a little more interesting. It's can you file for relief if you're oversecured? So, one of the triggers you have to hit to obtain relief from stay is that you're not adequately protected. You're not getting adequate protection payments, or the house is underwater. We have had some motions for relief from stay defeated because the house has significant equity. The court basically looks at it as, we're not going to blow up this debtor's plan. You're owed $50,000, the house is worth $100. You're eventually going to get your money. My thought is, well, why we have to sit 5 years and not get paid? So my suggestion is always, even if the house is oversecured, I would still file for relief, because more often than not, I do think some of the judges are somewhat sympathetic to the situation that you're not getting anything, even if the house is oversecured. And I think that's a stronger argument than for the debtor to come back and say, well, the house is worth more than what you're owed, so even if you don't get paid, you'll get paid eventually. I think you'd be in a stronger position if you're not getting the mortgage payments. Now, Gary and Erin, I'm kind of curious what you guys see in this area with regards to equity in real estate.
I've actually had a good amount lately since real estate started kicking off again, and there's been a majority of situations where we're not receiving those direct payments. There's equity, and sometimes significant equity, and we're filing, and we're either getting them cured really quickly, or we're getting a stipulation to cure and for future defaults, and they're not even making it to court. So based off that experience, and that could always change, I think we would have an argument in court, like Milos mentioned, but we're even in the situation where you're giving them time to cure and you're able to put that trigger in for those future contractual payments to you. in my view, that's a win-win. You're holding a hammer over their head so that you don't have to come back later on 2, 3, 4 years down the road and file a motion for relief again. So I would definitely normally go forward.
Yeah, I would agree. I use agreed orders with a default, clause in it. It puts, like Gary said, puts a hammer over your head that kind of takes care of that when there's, a lot of equity. Courts usually look down on actually automatic relief, being granted otherwise.
Okay, we have another question that came in on the chat. Another great question. What do you suggest we do when a debtor is paying their delinquent property taxes in a plan, but then defaults on their post-petition taxes? Okay, that's a great question because that actually comes up and it tends to lead to some complexities. I have always taken the position, even though if the taxes are not escrowed, the debtor is supposed to pay the property taxes, and then you find out that they default on the property taxes and you're sitting there as a mortgage holder, I always say that is enough basis to file a motion for relief from stay, because the house is losing value as those taxes are accumulating and you're losing your position equity in the property. I would always take the most aggressive approach, and I would file a motion for relief from stay and put the burden on the debtor to either cure the taxes or figure out something. We have had prior lenders that have actually, pursuant to the terms of the agreement, they've actually paid the taxes and then they want to recoup them. There's a couple ways you can do it. You could file a notice of post-petition fees, which is basically, I guess that's a whole discussion we can have for another event, but where you file a notice with the court, say, hey, we accumulated these post-petition fees, we're entitled to get them paid, we want to get them paid. I don't think that's the best route, because when that notice gets filed, then you're just kind of waiting for the trustee to pay it. But then if the debtor is continuously falling behind on taxes, you're going to continuously file the notice of payment changes. Nothing's getting solved. I always think the most aggressive approach is the best approach. So if you have a borrower, member, debtor, whatever you call them, that defaults on their taxes and you find out, I would probably file a motion for relief from stay to put the pressure on them. And if they don't respond, you obtain relief, or if they don't cure the taxes, you obtain relief, and you can proceed with your foreclosure or whatever you choose to do. So, and then, like I said, if you guys had anything to add to that, feel free.
Yeah.
All right. And then, we're set to go, I think, till, I don't know if it's 12 or 12:15, but, we're willing to stick around a little bit later to answer these questions. So if you guys want to stick around, we're trying to get through all of them. There's a couple more left, so we can stay a little bit later, if that's okay with Gary and Erin.
Okay.
All right. This one's kind of tricky. Does mortgage interest toll for the entire duration of any bankruptcy chapter filing to discharge or dismissal? Can it be added at dismissal? I think this goes back to what Gary said. And Gary, I'll probably let you take this one, but that should all be already been factored in the plan.
Right. You should. I guess part A would be you need to make sure that you're okay with what rate is in the plan, and the other part of that question, I think, has to do with dismissal, especially. If the important part to keep in mind with any bankruptcy is if that bankruptcy is dismissed, it's like it never happened. So if you were being paid 3% through the bankruptcy plan, and your contractual rate was 6%, and you had that additional interest that accrued during the bankruptcy, yes, once the bankruptcy is dismissed, everything reverts. So you can add that accrual back in. By the same token, beyond the interest rate, if the debtor was paying pre-petition arrears through the plan and maintaining their post-petition payments, and you only received part of the pre-petition arrears, when that bankruptcy dismisses, they're back to being due for the very oldest that they were due before the bankruptcy, minus any funds that you received that would have brought them to some more recent date.
Okay. I was just told we end at noon, but like I said, we could stay a little bit longer to answer some of these questions since Gary and I are on board. But similar question, I'll kind of get through some of these easier ones quicker. How do we compute interest paid for a given year when there are pre-petition arrears being paid through the confirmed plan? Those pre-petition arrears should be kind of quarantined off, and that should just be paid in a separate bucket, and you're just getting whatever the arrears are. You're essentially looking at the mortgage from the plan filing going forward. If a mortgage matures before the plan, do we also need to request ongoing plan payments for escrow? If the mortgage matures before the end of the plan, I would assume that unless it's like a balloon note, which we're not seeing much of, I'm assuming if it matures, it should be paid by then, or the plan should provide for payment of it in full over the course of the plan. So this is kind of a complex question, because if the debtor modifies the terms of the plan and it was escrowed, then there's going to have to be some sort of determination of who's going to take care of the taxes. Is the mortgage lender going to continue paying the taxes, and then are you going to get reimbursed? Or a lot of times what I would prefer to do is, if the debtor modifies the terms of the loan, I would prefer that the debtor picks up the payment of the taxes direct. Now, if the plan is set up in a way where the debtor is just paying the contractual loan payments, the escrow should be getting paid. And then if there's changes in escrow, you have to file a notice of payment change. If that didn't, whoever asked that question, if that didn't answer the question, you could call me and we could discuss it a little more detail. Motion for relief, when should we file for motion for relief? All right, that's a non-real estate question. I have to skip that one. Proof of process. Filed. Okay, so there's a couple more questions. There's about 2 or 3 that I want to get to. One that was just sent on the chat. If you file a motion for relief for non-payment, but the debtor brings the mortgage current afterwards, do you have to withdraw the motion? I would say no. I mean, once again, on the caveat, my personal experience, the districts I'm in, you could do one of 2 things. You could reach out to debtor's attorney and say, I'm not going to withdraw the motion, but I want an order that says if you default again, we don't have to go through this whole motion for relief process again. So we're going to send you a letter. You got 10 days to fix it. If you don't, we're submitting an order. It's done. We're not going to go through the motion response thing again. If the debtor's attorney says, no, I would never sign off on it, you can make that request to the judge. And you can say, Your Honor, the debtor's delinquent. He brought the account current like the day before the hearing. We're not confident he's going to be able to keep paying. We're willing to, we want an order to protect us down the road if this happens again, so we don't have to file another motion and go through the process. To be honest with you, unless the debtor's attorney agrees and this is maybe a first-time motion for relief, I don't see a lot of judges granting that. I think they're going to just deny the motion on the fact that they brought it current. If there's a pattern of this continuously happening, I think the judges would be more inclined, and I think you have a little more leverage against the attorney to get them to sign off on that. So I don't want to monopolize it. Gary or Erin,
same thing. I mean, I've had situations recently that exactly that situation, and we knew that they bring that mortgage current. We're gonna, if we have time, especially, we're gonna make an attempt, and if we can get them to sign off on default provisions in a agreed order for future payments, we'll do it right away. We just had one recently. If they say no, and like Milos said, it's a first motion, we would probably withdraw, because I would not feel that we would have a strong argument, and it would depend on judge too. I mean, if sometimes judges have their own methodology, and if I thought that it was a judge who might be more likely to fall on a creditor side, then maybe I'd give it a shot. But I generally, if they bring a current and we can't get a stipulation by agreement, I would probably withdraw. Now, if we were on a second or third motion, then I would really press the issue and say, no, we're not going to keep running up fees. And then I would feel more comfortable trying to get the court to weigh in.
Same here. If it's your first motion for relief and debtor will not agree to an agreed order, either way, I would withdraw the motion. If it was the second one, then I would push, maybe, actually attend the hearing.
Yeah, it seems like we got a consensus on that one. Another good question that came in. Can a dismissed or closed bankruptcy 13 be reopened if the foreclosure sale generates a surplus? I think the thinking there is, if the 13's done and then we foreclose on the house and we get a surplus, do we have to disclose it to the trustee? I think on 13, no, because the 13 is just a debt consolidation. It's if it's a Chapter 7, I would say yes. I'd say to an extent, because they do have an exemption as well on equity and on real estate, and it's pretty hefty in Ohio. It's like 100-something thousand. So unless that equity is over 100,000, I don't think that'd even be an issue in a 7. It'd be good to notify, obviously, whoever your attorney is, to see if the trustee should be notified. But in a 13, I don't think that's necessary at all, because they're not liquidating any assets of the estate. So we got one more question, which is not bankruptcy, but it's a pretty good question. Legally, how can debtors or debtors' attorneys not include debts within a bankruptcy plan? So we get this question a lot, and that's why I wanted to answer it. A debtor or debtor cannot omit any debt from their bankruptcy plan. So if you ever have a debtor that comes in and says, and this is going to be the last question, by the way, that says, we're not going to include you in the bankruptcy, or we didn't include you in bankruptcy, if they didn't include you, they made a mistake. If they say they're not going to include you, that's not true, because they can't. So if somebody includes you in a bankruptcy, in a Chapter 13, if they have to include you, and they have to provide for treatment of you, whether you're secured or unsecured. The Chapter 13 plan should state what they're going to do with your claim. So it's got to be included. It's got to be provided for. In a 7, you have to include everybody you owe money to. Now, if they don't want it include it, so to speak, in the bankruptcy, and they want to continue it, I think the only way out of that is for them to sign a reaffirmation agreement in a Chapter 7, which would reobligate them on that loan. And Garry, Erin, I don't know if you guys have anything to add on that one.
I would just add in quickly, don't rely on the fact that a debtor in a 13 says, I'm not going to include you, and then you just say, well, hey, they didn't include me, so I didn't get noticed, so everything will be great. In that situation, if they're telling you they're not going to include, be proactive, file a claim. If it's secured, file your plan objection. You just protect yourself. Don't rely on notice issues.
Yeah.
All right. So just a closing statement, just kind of let everybody know. Thank you, obviously, for attending the webinar. We always appreciate the attendance. Today was great. We had a lot of attendees, and really had some amazing questions. These are probably some of the best questions I think we've had in all the webinars that I've done, and I do appreciate that quite a bit. Makes us think and makes us realize that you guys are kind of getting a lot from these webinars. Just a reminder: a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. And we just want to remind everybody, we also have a complimentary library of over 30 webinars your team can view on demand. Our collection offers information on a variety of topics such as collateral recovery, real estate, and to name a few. We'll send you a link to the library in our follow-up email. And thanks again for attending, and enjoy the rest of your day. Thank you very much.
Thank you all.
Thank you.